Hello everyone, thank you so much for coming to this IHL talk here at the Geneva Academy. My name is Emilie Max and I'm a researcher here on focusing on international humanitarian law, and I'm notably in charge of organizing this series of events. It's really nice to see so many of you, including under the current circumstances. We have a couple of administrative health-related announcements to make, which are the list that you have all signed up to is only in case there is an issue here in the room today, and to give it to the health authorities for safety purposes. It will not be used to send you any kind of publicity.
Or send me emails.
Or emails, and it will not be used to ask you whether you want to join our executive master, which, by the way, you should, because it's really good. So here today with us to talk about the killing of General Soleimani, we have Professor Marko Milanovic, Agnès Calamard, and Professor Marco Sassoli. The point of this talk is not to provide a black or white answer as to whether the attack against General Soleimani was legal or not, but to show that there is a multiplicity of views and of questions to be asked and answered, and that each of those can be answered in a different way. And I hope that this is going to spark an interesting and rich debate between our panelists and with you as well. The way we're going to proceed is each of our panelists is going to have about 10 minutes to make his or her presentation, and then we will open the Q&A with the audience. Without further ado, if that is all right with everybody, I'd like to give the floor to Agnès Calamard, who is the UN Special Rapporteur on extrajudicial killings.
Well, thank you very much, Emilie. Thank you very much to the Geneva Academy for organizing this discussion. The targeted killing of General Soleimani, in my view, is raising fundamental questions regarding international law, international peace, and the international institutions that are supposed to oversee the use of force and the protection of global peace. That's my point of departure into my quick 10 minutes here are therefore to invite you all to see targeted killings as the lightning rod around which some fundamental questions around international law and international institutions are played out. At least that's how I approach targeted killings. I'm not suggesting at all in a context where we have seen hundreds of hospitals targeted by various parties to a conflict, that they are the only demonstration that international law is not implemented or is under crisis at all. I'm not suggesting that one single killing of one single individual is more important than the hundreds of civilians that have died in the rubbles of their civilian object, including hospitals. But what I would like to therefore highlight here is the fact that these targeted killings are extremely important, in my view, to unpack and understand for the purpose of understanding where we are at right now in the implementation and protection of international law, and in particular of the law regarding global peace and security, which are in fact 3 different bodies of law. My point of departure as well into the targeted killings of General Soleimani is the one put forward by my predecessor Christoph Heinz, which has consisted in arguing that in order for a targeted killing and a drone targeted killing to be lawful, it must be lawful under 3 bodies of law, or at the minimum 2, that include the law governing extraterritorial use of force, Article 51 of the UN Charter, and its interpretation, international humanitarian law, and international human rights law. So that's how I have initially approached the killings, and I continue to do so. For the purpose of this quick introduction, I'm going to highlight, first of all, be very clear that for me, the targeted killing was unlawful, and I have read nothing to this date that have changed my mind. I'm glad to be very much looking forward to hearing any other opinion. So what I would like to do here is highlight rather what I think are the implications of the targeted killing of General Soleimani and what it highlights from the standpoint of international law, including, of course, international human rights law. So the first point I think that is very clear is the general blurring of self-defense with reprisal or retaliation. I think you're going to elaborate on that point, so I may not get too much into it. There was already quite a lot of discussion and controversies over the concept of preemptive strike, a strike in response to an attack that has not yet occurred. But I think what has happened with the killing of General Soleimani, and indeed with the evolution for the last 5-10 years of the practice and doctrine, is the general blurring of the notion of self-defense under Article 51 and the notion of, and the fact that many of those targeted killings appear to be taken in response to past attacks. Repeated attack, a number of attacks, however you want to define them. The details that have been made available by the US administration after the killing of General Soleimani have added, to my view, to the general blurring. First of all, they themselves have been very confusing in their description of, in their public justification of the killing. Their stories have evolved. The statement, the report that they gave to the UN Security Council certainly moves away from the notion of response to an imminent attack. And what we have heard appears to suggest that in their reading of Article 51, it permits purely backward-looking retaliatory force that does not even aim to prevent further attack. Anthony Dworkin has argued, in fact, that the conduct of the US could lead to a new doctrine comparable to the old Bush doctrine, arguing for preemptive self-defense strikes, but expanding it further and including in that context state actors. So that's one point. The second point, I think that the targeted killing of General Soleimani highlights is a question of whether or not there was an international armed conflict at the time of the targeted killing, whether the strike itself amounted to a first strike under the theory of the same name and therefore triggered IHL and an international armed conflict, and so on. There are different interpretations here. With regard to the question or not of the existence of an IAC, the ICRC has argued rather convincingly that the first shot between nations make them belligerent, and therefore, in fact, that if the targeted killing of General Soleimani was indeed the first shot, it would have triggered IHL. They didn't say that. That's the implication of their doctrine, or indeed that the previous attacks amounted to a first shot. Others, however, have contested this idea of an ISC being triggered without any reference to concepts such as intensity, for instance. Here, I am referring here to the International Law Commission, who is suggesting that
Association.
Yes, association, sorry. Yes, association, indeed. That an ISC needs some kind of intensity like a non-international conflict. Myself, when I was looking at the strike, which, I wrote what I wrote within a few days after the strike, and I was very much wondering how to analyze it and whether it fell within whether the IHL should be the overall legal framework that I should apply to that strike. I was in contact with a range of experts, including many who argued along the lines of the ICRC, which is first strike, whether or not the targeted killing was a first strike or not. There can be debate as to whether a drone strike amounts to a first strike. But in any case, the overall feeling was that IHL applied. I decided not to go that route, even though I think at the time it was probably the predominant feeling. And I decided not to do so because, first of all, at a personal level, I did not feel that it was my role as a special rapporteur to suggest that there was an international armed conflict between Iran and the United States. And at the time I was writing, no one else had said so. No one else at that time had defined the situation as amounted to an international armed conflict. So I was a little bit, not lacking in confidence, but lacking in, being quite conscious of my role and the fact that it is not up for me to determine whether or not there is an international armed conflict. So that was the first point. I looked everywhere to see whether there was any kind of analysis of the situations before or after, or immediately after, as constituting an international armed conflict, and there too, I found nothing except a few, in fact, one analysis coming from the Geneva Academy, but overall there was nothing. And I did wonder, therefore, conceptually and legally, whether an international armed conflict could be determined a posteriori. I felt it was strange, to say the least, to suggest that for weeks maybe an international armed conflict may have been waged, but that the US Congress was not aware of it, or that Iraq was not aware of it. And I also felt that it was questionable whether the strike itself constituted a declaration of war. I also felt that at the time I was writing, everyone was very concerned with escalation, and I again did not feel that it was for me to escalate further the conversation by suggesting there had been a declaration of war. So for all those reasons, not all of which are legal or doctrinal or legal or doctrinal, I refrain from suggesting that IHL was the lex specialis. And you can agree or disagree with the political judgment I took at the time, but I'm still quite happy with that decision. Particularly because afterwards, for the last 2 weeks, in fact, debates for the months, debate has raged within the international community of experts as to whether indeed IHL was the lex specialis, whether indeed the strike constituted the first strike under the first strike doctrine, or whether indeed there was an IEC. at all. So I'm pleased I did not jump and suggested that IHL applied, and I'm quite, I think it's very healthy for us as an international community to be debating properly when can we talk of an international armed conflict, because it's a very serious topic, and that we also highlight the gaps in our political system, in our expert system. That if there was indeed an IAC, why is it that nobody talked about it? Why is it that from the moment of the first strikes by Iran, the retaliation, the post-retaliation, tit for tat, throughout December and January, there was no discussion in a formal way of at least the possibility that we were moving very close to an IAC? Why is it that the Security Council did not suggest that we were that close to an IAC? So that's one thing. Putting aside the vacuum, I think, in our institutions and in our understanding of what was the state of play by the time of the strike, I think the strike itself is also raising more fundamental legal questions. So I've already mentioned the question of which was the legal framework that should be applied, the question of lex specialist. Are we looking at a situation where only IHL should have been the dominant framework that we apply to that killing? Can we in fact look at it more from the standpoint of an integration of legal framework, including IHRL and IHL? And if it is the case, how do we integrate those two bodies of laws to analyze the targeted killing? I don't have an answer to that. I'm actually working on it. The other issue raised by the strike, which is fundamental, I believe, is the fact that it focused on a state actor.
And yes, I'll give you one more minute.
Okay. So the drone killing of a state actor was, in my view, is one of the most important development, both in practice and in policy. And in my view, that has also a great deal of implications, even though one can question whether what's happening in Libya right now, with some of the targeted killings of the UN-recognized government personnel, is getting also into that territory. Third issue is the targeted killings in a third state, and the question of unable and unwilling doctrine. What does it mean applied to Iraq? How do we handle the question of consent? I've taken a very clear position that, in my view, Iraq was another victim of that drone strike, but the targeted strike does raise a number of questions. And just to finish, I think, and to go back a little bit to the role of the international community and the notion of how do we handle situation like that one. After the targeted killing, it took at least 2 weeks for the US to present a report to the Security Council. Iraq submitted 2 complaints, one with regard to the US strike, the other with regard to the Iranian counter-strike. The Security Council has not met to discuss the strike, so creating yet another vacuum, in my view, even though you can kind of understand why they didn't. I think this is not, I think it's problematic. I also believe that the statement and the report provided by the US, in my view, is insufficient. We when we are dealing with a situation such as that strike, which brought us very close to a major problem, I think the international community should be in a position to request a thorough, in-depth explanation and justification. That has not come. We should have expected the US to provide evidence of the imminence of an external threat. That they did not. And therefore, they seem to be, again, pushing the doctrine further into a direction where Article 51 becomes almost empty, and where the original position, which was that the UN Charter and the institutions were meant to protect global peace and security, these are incredibly weakened after that drone strike and after the lack of reaction to the drone strike.
Thank you very much, Agnes. Marco, I'll give you the floor. I'd be particularly interested to hear you on whether you agree with Agnes' points raised under use of Bellum and the role of third states as well, and Iran.
Thanks, Emily. It's really a pleasure to be here and to see all of you in such numbers. I hope we don't have to spend more time with each other in quarantine, but if we do, it won't be that bad. Yeah. Sir, may I just say you have the best ringtone ever. I hope I have that. A very good thing for a conference, excellent. So let me, Emily, take up your invitation and sort of say something about but what Agnes was saying. So as Agnes correctly pointed out, for the strike to be legal, it needed to be legal under the jus ad bellum, the law on the use of force. As you know, the UN Charter, Article 2, Paragraph 4, prohibits the use of force between states. There's an exception, which is the self-defense exception, Article 51, which is the only relevant exception here. For it to be legal, it needs to be legal with regard to two states. So even if the US had some kind of self-defense claim against Iran, let's assume it did, it also had to have some kind of claim against Iraq, where the strike took place. It's one thing to kill Soleimani in Iran. It's another to kill him on the territory of a third state. Okay, so that's the jus ad bellum issue, and I will spend most of my time on that question. But then there's two other bodies of law. One is international humanitarian law, and the other is international human rights law that are also implicated. When it comes to international humanitarian law, Agnes spent quite a lot of time on this whole question of did it even apply, which is a big issue. It's not an obvious issue. The reason I think why you and others have this existential angst, as it were, about whether it applies or not, is because of the bottom line, if it did apply. Because if it did apply, it is reasonably straightforward, I would say, that under IHL, if state A kills a general of state B, that's lawful. It's also reasonably straightforward that if state B launches missiles at the military base of state A, that's also lawful. These are military targets. IHL allows you to kill military targets. It's fine. What's complicated under IHL is, for example, the whole question of bystanders, civilians who may have been there, etc., etc., etc. Soldiers from other states, which is the Iranian response. There were some, Czech or Bulgarian soldiers in that base, so what do you do then? But I think that's the problem with the applicability of IHL, is that it somehow leads us very easily to an answer, which is that the strike was legal. And I, at least, am not satisfied with that ease, as it were, because IHL is not the best fit for this type of situation. And that brings us to the third body of international law that regulates this type of situation, that's human rights. Under human rights law, we also have threshold applicability questions. So many powerful states have resisted for a very long time the idea that human rights law can apply extraterritorially. That's question number one. When America kills somebody not on US territory, but in the territory of Iraq, does, for example, the International Covenant on Civil and Political Rights protect that person? This is not the first time we've dealt with this question. Anything from killing Osama bin Laden to Guantanamo has to deal with that extraterritorial dimension. But I would also submit that that question is separate from this whole question of interaction with the law of armed conflict, because the extraterritoriality issue also arises in pure peacetime situations. So Agnes, for example, was recently involved in this investigation as to whether the Saudi crown prince hacked the phone of Jeff Bezos. Okay? When Saudi Arabia hacks the phone of Jeff Bezos, does he have the right to privacy? Is a question of extraterritorial application that has nothing to do with armed conflict. You see what I mean? And for whether it's armed conflict or not, my view is that we should have consistent answers. And in principle, that human rights law should apply across the board. That's my view. Right? Then the second question is, how does human rights law interact with IHL if both did apply? And here is where I effectively think that the stakes sort of IHL applying are not that high. Because this is precisely the type of situation where we're not dealing with a traditional battlefield. We're not dealing with 1,000 soldiers of one side shooting at another 1,000 soldiers of another side. It's not absurd to apply the more demanding human rights standards in a situation like this one. And human rights law generally requires exhaustion of non-lethal means before you resort to lethal force, and requires you to show that you have to kill that person not on account of their status, as in IHL, but because they're posing a threat to the life of somebody else. So under human rights law, I would submit killing Soleimani is much more questionable than it is under IHL. But the third body of law, the body of law I want to focus on, is the jus ad bellum, the law on the use of force. Now there, the cardinal principle that was laid down by the ICJ in the Nicaragua case is that we should judge a state's use of force by the formal justification that that state itself gives publicly. We shouldn't speculate. We shouldn't invent things. We should see how the United States justified its resort to force, and we should judge the validity of that justification. Now, the problem here, as Agnes pointed out, is that the justification offered by the US government has been, shall we say, a shifting one. The reason why that's the case, as far as we know, is because the whole thing was improvised to an extent. I doubt it was lawyered up too much before the whole thing happened. You may have read the report in the New York Times how the US Army, various military people, offered President Trump a list of options he could take to deal with what they perceived as an Iranian threat in Iraq, putting there as sort of the extreme measure that they thought he would never take, killing Qassem Soleimani, and that's what he did. Right? So it's very likely that, it was a relatively impulsive decision, and therefore when the US government had to speak in the language of international law to justify what it did so in a somewhat more improvised fashion than it normally does. So how did this justification shift? Well, first, when you look at the various statements, whether it should publicly by, say, the Department of Defense, or by President Trump himself by tweet, they first spoke of the necessity to kill Soleimani to prevent a future imminent attack. Then there was a lot of pushback on that particular front from, various actors, the press, politicians in the United States, members of the U.S. Congress, especially the intelligence committees of the House of Representatives, of the Senate, who saw the intelligence and said, this doesn't really look that great to us, So they shifted from that justification to saying, effectively, we need to kill him to stop an ongoing series of attacks. And so that's the difference, really, that happens, that shift in the U.S. argument. And so if you compare the letter that they sent to the Security Council to the initial statements that were made, you can see that shift, right? So the shift the current, at least as we can say, position of the U.S. government is that they were trying to stop an ongoing series of attacks. So let me first very briefly talk about that. Article 51 of the Charter says that a state has the right to self-defense if an armed attack occurs. Okay? So mainstream sort of literature of international law has said that means exactly what it says. You can't use force in response to an armed attack that is over. Okay? If it's already over, there is no necessity to respond by force. You can respond in other ways. So that's what Agnes said was, the whole question of armed reprisal. If all you're doing is using force against the state because it did a bad thing, what you're really doing is an act of reprisal, of revenge. You're not stopping, you're not using the measure you have to stop an ongoing attack. So for example, if Emily punched me in the face, don't, right? But in the act of her punching me, I could act to defend myself. But if she punched me yesterday, and today I respond by force, that will not be regarded as self-defense under any criminal law of any domestic legal system, because there's no necessity to respond to an attack. Okay? So the same thing is basically in international law. If the attack is ongoing, then you have the right to defend yourself. But a controversial issue for many, many, many years has been, do you have the right to defend yourself if the attack has not yet started, but it's imminent? Okay? It's a future attack. Now, traditionally, people who are proponents of that view have interpreted imminence as a temporal criterion. Okay, so Emily is saying, I'm going to punch you now, and at that moment, that imminence exists. It's about to happen. Understand? So I don't have to wait for her blow to land on me before I take preventive action. The tanks are about to roll across the border. You don't have to wait for the tanks to start firing and to cross your border. You can attack the tanks first to stop them from actually inflicting much harm on you. So that's the traditional theory of self-defense in response to an imminent attack, where imminence is seen as a temporal criterion. However, many powerful Western states in recent years have actually weakened that theory because they think it's too strict. And they have started saying imminence doesn't mean something that's about to happen. It means something that is certain to happen, or reasonably certain to happen, and we need to respond now. So basically what they're saying is it's necessary to respond to it now because it's our last opportunity to act, even if the attack does not materialize tomorrow or 2 days from now or even a month from now. So this is basically recasting imminence purely in terms of necessity. If you want to read more about it, there's a whole effort by Daniel Bethlehem, who was the legal advisor of the Foreign Commonwealth Office, who then published in his private capacity after he departed his position an article in the American Journal of International Law where he sort of pushed forward that type of theory, saying it's just my own view, even though it's informed by the view, by many discussions I've had. And then you have several legal advisors, existing legal advisors currently of states, endorsing that theory verbatim. So this was done by the legal advisor of the State Department, by the Australian Attorney General, by the British Attorney General. So you can see how that type of normative sort of entrepreneurship works. I'm not saying it's illegitimate, that's just how it works, right? Okay, so you understand where we are. So there's the issue of whether the US was responding to an ongoing series of attacks or was trying to stop an imminent attack. I'm going to finish, sorry. Now, under either theory, there are problems. The ongoing series of attacks theory is very problematic because there's actually no series of attacks that is sufficiently temporally, causally proximate. If, for example, you are firing artillery shells across the border at your enemy, or you're bombing them from a plane, obviously there will be breaks in the violence. The plane has to land, refuel, take more bombs. They have to reload the guns. When we say there's an ongoing series of attacks, that's what we mean, So there will be some points in time where there's no violence happening, but it's all part of a chain of events, right? But when you see what the Americans are saying the chain of events was here, it's basically a year of daily life in the Persian Gulf. Bad things happen from time to time. The Americans say, well, the Iranians did it. They put limpet mines on tankers in the Gulf, or they sent drones to target Saudi Arabian refineries. But there's months in between each incident. They're not really directly connected. Okay? It's very hard to say this is an ongoing series of attacks. when it comes to the imminence theory, initially it seemed that the US administration had in mind some specific event, and that this was actually probably going to be another attack at embassies. So President Trump spoke about us stopping a series of attacks, future attacks on embassies. But then that whole thing dissolved because probably from what members of the American legislatures themselves say, they don't have good enough evidence to support that theory. Okay? So one problem with the US argument is that the predicate for self-defense, an ongoing or imminent attack, is probably not there. The second problem is the whole necessity question. Is killing that specific person, and proportionality, right? But is killing that specific person necessary to stop or prevent the attack? The problem with that argument is that Soleimani was not operationally somebody who was running attacks. He was far too high up. If it's necessary to kill Soleimani, it is necessary to kill Ayatollah Khamenei. You understand? He is that high up. He was the second or third person in the country. And on the contrary, what we learned after the killing of Soleimani took place, the attacks by Iran against US interests in the region escalated, as you could expect them to escalate. They didn't stop. So it's very hard for the United States to actually say that killing Soleimani was necessary. I mean, we can talk more about this if you're interested. So my bottom line is this. Even if you accept the US own legal theory of the right to self-defense, which is a very expansive one, it is highly unlikely that the US will be able to meet the evidentiary burden it would need to meet to justify killing Soleimani. By the way, that doesn't mean I think that General Soleimani was some kind of super nice guy. He was probably a very nasty guy. It's not like I'm, teared up because of his untimely demise. It just means that the United States government is probably not able to prove that killing him was the measure of last resort it had to do. Okay? I cannot say this with 100% confidence because I'm not privy to all the intelligence that the US government is privy to, nor is any one of us. But from what they have been able to offer publicly, it seems to me almost certain that the killing of Soleimani was ad bellum unlawful. And that also basically means it was human rights unlawful, because to kill him under human rights law, you would still have to show that he was posing an imminent threat to some specific person. There was a real immediate risk to somebody else's life, and I don't see that you can show that, even though, again, he was not a particularly nice guy. So, a final note, the question you actually started with, I'm sorry about that. Right, so, and again, you also have to prove that it was necessary to kill him in Iraq, because you have to justify going onto Iraqi territory where Iraq did nothing, basically, to either consent or to justify the resort to force. My final point is to say that it's also clear that the Iranian response was unlawful. So the missile strike against US bases was also a violation of Article 2.4 of the Charter, was also a violation of Iraqi sovereignty, precisely because the attack was retaliation for something that happened. It's not like the Americans were going to attack again and the Iranians needed to destroy the military bases to stop them from doing it again. It's that it was a proportionate revenge, but still revenge, for what was done, and therefore is ipso facto unlawful. And in fact, if you look at the Article 51 letter that the Iranians sent, they don't say about stopping an imminent attack or an ongoing attack. All they are saying is we reacted to something that already happened, which means it was unlawful. So that's me. Thanks.
Thank you very much. Professor Sorsani, can I give you the floor to talk maybe about the existence of an international armed conflict and to agree or disagree with anything that Agnes and Marco have said before?
Well, thank you very much. I mean, this discussion is the dream discussion at the Geneva Academy because although I obviously agree with Agnes that there are, from a humanitarian point of view, more serious things today to discuss. But I mean, here we are at the Geneva Academy, and this case is at the intersection of use ad bellum or use contra bellum, that's the prohibition of the use of force between states, the international humanitarian law, international human rights law, and probably also, so we will not speak about it today, international criminal law. Now, underlying is obviously a question, what is international law? If we all end up in a quarantine together, we can have time on that. I'm still one of these old-fashioned people who think, like James Beatty wrote in 1920, despite all modern theories, international law still has something to do with states. Then there is an interesting question on which someone should write a thesis. It's the explanations issue. Mm-hmm. I don't know. I am always very skeptical when NGOs write the burden of proof is on X or Y, because typically, as most lawyers, in particular of Anglo-Saxon training, they apply courtroom rules. I'm not sure that in international discourse there is something like that, but we should clarify who has to give explanations for what. And one old-fashioned rule here would nevertheless be that those who invoke an exception to a rule have to explain that the exception are given. For other things, it's more complicated. Now, on jus ad bellum, I largely agree with Marco. We are both Marco, only K and C.
K and C, yeah.
Now, there's simply a little reservation between imminence and past self-defense against the past attack. Don't make it a catch-22 situation where if I react after the attack, then it's a violation, and if I act before the next attack comes, it's also a violation. I think there are also good policy reasons. I would recommend states not to act immediately, but first to think. And therefore, obviously, if the regime of a country changes or if a state apologizes, then this is clearly revenge. While if, I don't know whether these are the facts, but I mean, if there's a series of attacks, I can wait some time, and then it's somewhere in the midst of preventive self-defense. But you didn't really say the opposite. One issue I wouldn't do is to individualize necessity. We don't care about, obviously, as a human being, I'm always regretting that. But we don't care about General Soleimani. It's about Iran. Did Iran threaten the United States? And then, in my view, also I see your point about necessity. We don't care which general is killed to stop that. And there must not be a link between his behavior. This is even dangerous because it brings somehow a human rights criterion into jus ad bellum, which in my view is an interstate law. Now, on human rights, I agree that they continue to apply in armed conflicts. I'm also of the opinion that they apply extraterritorially, but how far? This is nevertheless a question, and I must say it sounds strange to say that General Soleimani was under the jurisdiction of the United States when he was killed. I'm still somewhere of the opinion that you have first to be under the jurisdiction and then the violation commits, and you cannot be under the jurisdiction just because the violation commits. And if this was true, and I know some eminent human rights specialists are of this opinion, then we have to apply it to everything, including to the right to food. And therefore, Switzerland violates the right to food. Obviously, if there is a hypothetical causality, this is necessary. If it doesn't feed people somewhere in the world which it could feed, and because it doesn't feed them, those people are deprived of the right to food, and also the obligation to protect, which is also part of the right to life. if there is hypothetical causality. So if the US is able to protect the life of someone in Madagascar but doesn't, then violation of the right to life. And then on the collateral damage issue, or the incidental injury to the people around General Soleimani, I just wonder whether in human rights law it's not also admissible. But I mean, you are the expert, you will tell me. But I never understood human rights law as saying if there is an imminent threat to human life, that I cannot take the risk to kill other people than the one who provokes the threat. Now let's come to IHL. The first shot theory is admittedly artificial, but it doesn't lead to absurd results. All on the contrary, if we don't adopt it in other fields than killing, for instance, a soldier which enters into a country, is arrested, but enters not because he made a mistake, because he got orders to enter the country. For entering without a visa, if the law of international armed conflict does not apply, he can be tried, as all of us, if we enter the country without a visa. I think it is reasonable to apply the law of international armed conflict. But obviously, I agree that politically there is a certain escalation risk. And therefore, perhaps we should call it otherwise. We should simply say, look, it's IHL of international armed conflict which applies to this situation, but not say, now there's a war between Iran and the United States. No, please. Just this little event was covered by the law of international armed conflict. In addition, if you don't adopt the first shot approach, then you have a problem with the ex ante. How do you know that this was the first shot and not like the famous Caporal Peugeot, who was the first French soldier killed in the First World War? But then the war went on for 4 years. So you must judge before you know how the things continue. Now, if, as I think, IHL applied, then I think nevertheless when a general is targeted, then IHL is the lex specialis between two states. Sorry. I mean, we said, many of us said, when the US targeted in the Pakistani tribal areas with drones, we said, okay, if in the Second World War the US had killed Japanese generals, that would have been okay. And IHL likes, sorry, Agnes, likes targeted killing. It doesn't like indiscriminate attacks. And therefore I'm in favor of in-armed conflict, of targeted killings of legitimate targets. And what we said is, but look, in the tribal areas there's no international armed conflict, and second, we don't know whether these people are really legitimate targets. And I must say, your theory, rather, my wife would like your theory, because she is very shocked by the fact that I say that my son, who is a soldier in the Swiss army, is a legitimate target when the French attack Switzerland. She is shocked by this sentence. And therefore, now I can tell her, yes, but look, under human rights law, the first
I just imagine a dinner at your house.
Yeah, no, but he is no longer. Okay. And just a last point, on the necessity and Chapter 9 in the ICSE guidance on direct participation in hostilities, several people in this discussion have, in my view, misunderstood it. It is not like in human rights law, a general issue of necessity. In the sense, you don't have in an armed conflict to say, is it really necessary to kill this general, or couldn't we kill perhaps the colonel under him, and is he high enough, and so, which under human rights law is indeed an issue. But it is just about the capture issue. And here I think, well, the US has a good argument they couldn't capture General Soleimani. So to conclude, I agree that to the best of the facts we know, use ad bellum was violated, but I think humanitarian law was not violated, and humanitarian law is the correct analysis, not of the overall legality, because as you rightly said, it has to comply with both use ad bellum and use in bello. And obviously, the fact that it, and this is very important, the fact that it respected use in bello means nothing for use ad bellum, but means something for human rights law, at least when a general is killed in an international armed conflict. Thank you.
Thank you so much. If that's all right, maybe I can give each of you 1 minute to address things that Marco raised and that you're interested in, and then we'll open the floor to questions. Anya, do you want to start?
There was so much being said. I want to react to the point you have made that under IHL, the targeted killing of General Soleimani would have been legitimate. I'm not convinced. I'm not convinced for two sets of reasons. The first one is that three reasons. The first one is if we agree that there was let me rephrase it. Can a killing be legitimate if it does not meet Article 51? In other words, can a killing under IHL be lawful if it is unlawful under the question of imminence and so on? So that's the first question, and I'm not convinced that it is the case, or at least I think we need to ask that question. The second reason is I still think that even though General Soleimani was indeed a legitimate target under IHL, as I did say at the time, I do believe that the targeted killings of combatants must be guided by military necessity and proportionality. And I am not, at least I don't have sufficient information to conclude that his killing was indeed guided by military necessity and proportionality, because we also need to remember that in addition to him, at least 5 or 6, the numbers have changed, but I think at least 5 other people were killed. So, and I will not want to ignore them. And I think we need to remember that there were quite a lot of collateral damage in loss of life. So that's my first point. The third point, I think, the more general point is my fear with the position put forward is that we could have a generalized situation of war or pre-war or possibilities of war if any generals can become a legitimate target even when Article 51 does not apply. Aren't we opening the door to an Hobbesian situation? So that's the 3 points I want to make at that. And I have many more because it was so rich. But I'm just going to put those.
Marco with the cake.
Thanks. So I think what's striking here is how basically a lot of our substantive positions are driven by our own policy preferences and sort of our ideological commitment to a certain body of law. So, for example, Marco is really an IHL guy primarily, and you're allergic to things that too much impinge on that. And Agnes is very much a peace-loving person, and a human rights-loving person who wants to prevent escalation. And I'm just somebody who likes talking for a living. But okay, bearing that in mind, your point about ad bellum legality, you felt uncomfortable, as a peace-loving person would be, with the idea that something that's unlawful under use ad bellum could still be lawful under IHL. But that's what we teach our students. You know, that's 101. The US invades Iraq. It's a clear violation of the UN Charter. But when a US soldier kills an Iraqi soldier, that's okay. You know, under IHL, that's okay.
Yeah, but this is a completely different situation.
Because it's a one-on-one thing.
Exactly. So I think you need to acknowledge
I agree.
it is different.
I agree. But where I would say that...
Because if the targeted killing itself was not in response to an imminent threat, how can it be therefore guided by military necessity? And that's, I mean, I'm not necessarily saying it's not.
I agree with you.
But I just say I think we need to ask the question.
I totally disagree.
Okay.
Yes, so your point is that basically you think that every decision in armed conflict is to be guided by military necessity, but Marco will now tell you
disagree.
That's not true.
No,
killing a soldier is presumptively okay.
Yes.
But where your point, I think, makes more purchase is the relationship with human rights and the use at Bellum. So if you look, for example, at the Human Rights Committee, General Comment 36 and its jurisprudence, they're saying, if you kill somebody when using force contrary to the UN Charter, the death is ipso facto arbitrary in violation of the right to life. And that's, it's questionable to what extent that's a desirable interpretation of human rights law, because it means human rights bodies now have to determine the use ad bellum legality of whether Russia took control of Crimea, etc., right? I personally don't think it's desirable. But it's intellectually consistent to say that if you kill somebody in violation of the use ad bellum, it's a human rights violation ipso facto. Marco, to your point, I thought you said, correct me if I'm wrong, that you thought human rights law doesn't allow for collateral damage.
No, I would rather say, I think it allows.
It does.
It does.
Yeah. It does.
Exactly.
We're all agreed. Yes.
Okay.
Excellent.
So the famous 5 others, we don't care if this was really imminent threat to human life of many Americans.
Exactly. I mean, the best case here is the Finogeno case before the European Court of Human Rights. So there's a terrorist hostage taking in the theater in Moscow. Hundreds of hostages are taken by the terrorists. The Russian special forces pump in this anesthetic gas to sort of disable the terrorists so they can save the hostages. In so doing, they kill hundreds of hostages. And the European Court of Human Rights does not say that the right to life of the hostages was violated because gas was used. It says the right to life of the hostages was violated because Russian hospitals were not prepared to take relief action and to help people who were afflicted, not because in a situation as traumatic and extraordinary as that one, the Russian special forces couldn't spare every civilian. Right? So human rights law does allow for collateral damage. It does. Extraterritoriality. So basically, you did the whole argument ad absurdum, right? So it leads to so many absurd results that the Switzerland has to feed the hungry of the world, that human rights law cannot possibly apply extraterritorially. Well, yes, if you take it in such an extreme level. I mean, my own view would be that negative obligations should apply without any kind of restriction. So if Switzerland bombed a farm somewhere in some country, that is a violation of the right to food. Okay? But positive duties do not apply without that jurisdictional criterion. So Switzerland does not have the positive obligation to feed the hungry. There's a distinction there. And there's that distinction between action and inaction is all over moral philosophy for thousands of years. It's not like I made it up.
But it's a dangerous...
Yes, I agree.
No, you practically say civil and political rights are serious and economic and social rights.
No, if you bomb a hospital, that's a violation of the right to health. If you poison a well, that's a violation of the right to water. If you destroy housing without killing a person, that's a violation of the right to housing. So economic, social, cultural rights would also apply, but they would apply in their negative dimension, always, not just in their positive dimension.
Can I give you one more?
Yeah, I'm done.
Okay.
Sorry.
Can I just react though, because I respectfully disagree with your analysis of international human rights law and the so-called collateral damage. The example you're taking is not, in my view, the one that is the most logical comparison. I think the logical comparison will be a situation of excessive use of force with the police responding to, let's say, a demonstration or targeting one specific individuals and killing a range of others in the country. I agree that human rights law does allow some kind of collateral damages, but they need to be understood within the principle of necessity and proportionality. And I do not see how, in a context where, let's imagine here that you are going to target General Soleimani and you are made aware of the fact that he is surrounded by 6 other supposedly civilians or people who have no connection to him or to what, under international human rights law, you will not target him. You will not go and proceed with the killing knowing that 6 other people are going to die. I think under international human rights law, you cannot justify that if you have that knowledge of him being surrounded.
So we do disagree
by these 6 people.
No, the two Marcos disagree with the one Agnes.
You will wait for different situations where you are able to target him without killing 6 other people.
So that's the question. Can you wait? Will that such an opportunity present itself? So if you think there will be such an opportunity, you're right.
If we are not under an international armed conflict situations, if we are applying human rights law, I see absolutely no justification in proceeding with killing somebody knowing that 6 other people are going to die who are innocent.
If I may, I suggest that we open the debate to the rest of the room. I've already seen one question at the back, but I suggest we take 3 at a time. So we have one at the back, and then I'm going to do one with the gentleman with the yellow tie, one at the back, and I know that you one for Ashley. So we can maybe start with Elena at the back.
Thank you very much. It's really more comments than anything else because I'm a little concerned about some of the stuff that's been said here. First of all, to Marco,
can you speak up a teeny tiny bit?
Sure.
Thank you.
To Marco and Agnes, I do recognize, of course, that you do policy interpretation of the situation, and Marco has just commented on it. What I want to say is I think acceptance of that is not such a good idea because it works both ways. In this particular situation, and I'm not at all going to talk about the specific incident of General Soleimani, we've had situations in the past where states have called war something that is not war. So similarly, calling something that is war not war has its own implications. Therefore, what I'm saying is that my sense is that rigor is necessary in classification of situations because the law is the first and primary goalpost you have, the signpost that tells you how to deal with the situation. So, everybody in this room, I assume, would like to go to the human rights route, but what I'm saying is that nobody in this room has the only authority to classify. And classifications can go both ways, and I'm pleading for rigorous application of the law. Secondly, I also think it's rather dangerous to say that, as Agnes has said, that can IHL really be applicable killing be applicable legitimate if a situation is not lawful under Article 51 of the Charter? And the answer, of course, is that these 2 bodies of law are entirely separate. And they're separate for good reason. And they have to remain separate unless you want to introduce entirely subjective determinations of what is a just war, in which everything would be allowed, or IHL would be allowed, and then an unjust war in which it would not. I mean, this theory has really gone away with the Geneva, 1949. It's over. And to reintroduce the notion that something cannot be legitimate under IHL because it's not legitimate under the use of Bellum is a very dangerous path. It's an extremely dangerous path because at the end of the day, lawfulness is always in the eye of him or her or the state, rather, who introduces the first action. So I think that's incredibly scary. I think another convolution of IHL is to suggest, similarly, I think Marco beat that back a little bit, is that the targeted killing, which is, by the way, not an IHL term, but never mind, of competence somehow requires necessity. I mean, there is status-based targeting, as we know. There's no issue of necessity unless, situations of where competence of ordre de combat, this is not what we're talking about. So that's, again, that's just a misinterpretation of IHL, and my suggestion is that that would be, to my mind at least, rather scary. And then finally, last point, is this first strike theory has come up over the last several, I would suggest, years, and to my perplexion, because, again, for reasons that are very well known, and I don't want to go into them, you can... IHL and IAC doesn't have the same threshold as IHL and NIAC, and therefore there are reasons, and Marco has given an example, Marco Sassoli at least, for which IHL becomes applicable in, at a very low threshold of IAC. It's a different thing whether states are politically going to accept that, and whether, as has been mentioned, one should go and say then it's war. That's a different issue, and that's why one of the reasons I would suggest that everybody was silent after the strike on General Soleimani took place, because the politics of saying it's a war were just hugely enormous. But I appeal for legal rigor, and there are pretty clear guidelines in the law of IAC, and there's a reason for that, and so sort of chipping away at them because somebody's policy considerations may not agree or ideological considerations can work both ways. And it's a really dangerous path to go down. We all need criteria that everybody can apply and everybody can be called to in a situation that is as grave as armed conflict. So thanks very much.
Thank you. Over here?
Yes, thank you. My name is Yahya Obaida from the Iraqi mission here in Geneva. So, it is not a secret the tension between the interrelationship between the United States and Islamic Republic of Iran and its reflection on Iraq. And also, it's the both of them support Iraq and this political process and the election and his war against ISIS, against Daesh. And it is not on the strike at that time. It is not just only General Qassem Soleimani killed. There's some Iraqis killed. One of them, Abu Mahdi al-Muhandis. So in his letter, in his message on 3rd of January, Iraqi Prime Minister described the operation as assassination. And when he talks about the killing of Abu Mahdi al-Muhandis, he described it as aggression because Abu Mahdi al-Muhandis is deputy chief of the Popular Mobilization Forces, which is a part of the Iraqi security forces and related directly to the Prime Minister office. So it is the deputy chief of formal forces. And he described the killing of General Qassem Soleimani as a gross violations of Iraq's sovereignty. So I have, if we talk about the legal framework, I have two letters submitted by the Iraqi foreign minister, one of them in June and one of them in September.
Your question?
Yes, this is the question.
Yeah.
I have two letters, one of them in June and one of them in September, and these two letters determine the task force of the coalition forces, including the American forces. And also there's a resolution adopted by consensus on 14th of December 1974, the definition of aggression of the General Assembly resolution regarding the definition of aggression. So I put these three letters before you, and you can decide or describe the legal framework, and I can quote some of them if you have. Just a little,
we have
little one. Yeah.
No, we have 20 minutes left, and I would like to also give other people.
It is here in the letter. It is for these.
Sir.
I'm sorry.
Do you have maybe a shorter, more direct question?
I know, but I want to put this paragraph
I understand,
before
but maybe
them
you can
to
give
judge.
Basically, your point is that exceeding the consent of the state would count as aggression. That's the point. The point you're making, right?
Thank you.
Yeah.
Thank you. The gentleman at the back, and then you two at the next round. If that's okay. Yeah, go ahead.
I'm going to stand up because it's easier. I'm Victor. I'm a student from Bellum at the Garage Institute. I think that, as Professor Milanovic pointed out, you disagree in some points, but I think that something you all agree is that there isn't enough information. There is a lack of information on what happened here. So this takes me to maybe something that is not the focus of the issue here, but on what's the role of intelligence agencies in this situation, because clearly they withhold much more information that could verify the situation. So we might talk about what happened, but my question is more of how to deal with this in the future, taking into account this agency's role in this situation. Thank you.
Thank you. Should I start with Professor Sassoli?
Well, I have just a point. I agree with what you said, that indeed there is a serious issue in human rights law. If I understand correctly, there are some requirements of transparency where you can say that the state must clarify some things, while neither in views at Bellum nor in humanitarian law, in my view, there is anything like that, and therefore the general question is who has the burden of proof. And I see too many lawyers who simply apply courtroom rules to this, which perhaps is correct, but then one has to write a doctoral thesis to explain this, why the world is a courtroom where someone has the burden of proof, which is not so obvious.
No, I think.
Oh, okay. I would love to read the letters that you. So if you could give me a copy, that will be great. I mean, I think at least the two of us have certainly acknowledged the. Can I keep them?
Yes.
The two of us have acknowledged that I've used the terminology of victim when I refer to Iraq as a whole. I mean, there is no doubt to me that Iraq had many claims that could be made. I regret that Iraq did not push the issue on the agenda of the Security Council as it could have. I understand that it decided not to, but to me the best. And that's also with your questions around information. The strike has highlighted the absence of space and institution to handle it in a way that also was not participating to a process of escalation. And that's very difficult. And I understand why immediately after the strike, the main focus was to avoid falling into a major conflict. I feel that, once that possibility had been put aside, as at least temporarily, the Security Council should have discussed the issue upon the request of Iraq. That has not happened. And to me, there is a problem here. We are facing a problem.
7th of January.
No, yes, I know you submitted. I know you submitted letters, but I have followed that up in New York, and I know for a fact that the Iraqi PM and everyone else, as the president of the Security Council himself, have made the active decision not to pursue the issue and to put it on the agenda of the Security Council. And I understand the logic behind it. I regret it. I think I understand it immediately after the strike, I think that now there could be a space where this could be done. There is an awareness within New York, at least within member states, that this kind of situation is not good. So Mexico has made a specific proposal on how, in the future, the member states could deal with the use of force in such situations. Let's see how that proposal is going to go. Liechtenstein has also raised similar issues. There is an overall feeling in New York that as an institution, the UN, the decision-making bodies must find a way of handling those situations far better than what was done in that particular situation. I think the strike is also raising similar related questions of how do we interpret the non-reaction. In other words, if the international community does not react formally to the strike or does not oppose it, does not endorse it, does not say much about it, what is the legal meaning of that non-reaction? There are a couple of experts that are starting to work on that issue. I think it's a fundamental issue that is in relationship to the fact that there is no space, seemingly, that we are not constructing that space for whatever political expediency or fear of escalation or whatever the reason. To me, the strike is highlighting those gaps. It's highlighting our weaknesses as an international community, in addition to the fact that the UN Charter is under a great deal of duress. And I think it's up to us to come up with, or to think, both as expert or as active member of that international community, to think of processes, institution, mechanisms of response.
I completely agree with what Ines was just saying, and it's also reasonably clear to me that no matter how unlikely it is for the US to be able to prove the factual predicates for using force against Iran, it would be even much more difficult to prove that it had to do it on that day on the territory of Iraq. So even if the US had a legal claim against Iran in self-defense, that does not obviate the need to respect Iraqi sovereignty. And I would add to that, to your point that exceeding the scope of consent given can count as aggression, I would also just point you, obviously, to the fact that the Iraqi parliament initiated a whole process of requesting US troops to leave, which then the US government met with rejection. Now, it's unclear where that's going, because it's not like the Iraqi government formally told the Americans, bye-bye, go now, and the Americans said, no, we won't. But if that ever happened, that would be a clear violation of the UN Charter, because it's simply you are not allowed to do that, right? I mean, for whatever reason you might have. Victor, on your point about facts, and I'm just turning also to Marco's point, it has always been thus. That when states make claims against other states of all kinds, not just use of force, it can be anything, it can be trade, it can be investment, it can be viruses, whatever, that the facts might be in dispute, there's no centralized body that will just establish the facts. The courtroom that resolves many of these disputes, at least to some extent, is really the courtroom of public opinion. And the question is what a persuasive argument is, and what states can do and other actors can do to make their arguments more persuasive. The current issue where we're faced with that type of difficulty the most is cyber attacks. How do you attribute cyber attacks? Because bombs are easy to pinpoint to. Cyber attacks much less so, and you can find some instructive examples there. For example, states collectively doing attribution. So Russia allegedly conducted recently a cyber attack against Georgia. It's not just Georgia who said Russia did it to us. It's all of European Union member states and America and a bunch of other states who jointly said, we think Russia did it. They didn't tell you how exactly they know that. because they don't want to disclose their technological know-how or whatever. They didn't analyze the code and tell you, here's our analysis of the code, and let's put the code out there in public domain. But the fact that a bunch of states does that collectively is probably more persuasive in the courtroom of public opinion than if just the victim state did it. Or, again, in the cyber context, you have corporations do that more and more often. So not just states attributing cyber attacks, but Facebook and Google and whoever it is saying, we think North Korea did it. But that's always our problem. As Marco rightly said, there's no rule that a state has to disclose evidence at its disposal. But if it does not do that, it risks making its argument be less persuasive in the courtroom of public opinion. That's just how it is. And I don't think we can regularize that in any kind of formal way.
Well, I personally will be maybe speaking as a peace lover, whatever you want to. I believe that if we are talking here about extraterritorial use of force, which brought the world very close to a major explosion, I'm not sure we can suggest that the US had absolutely no obligation to explain and to justify why they had done so.
Yes, but they don't have the obligation to disclose their intelligence products and whatever,
Yeah,
they don't have to open the CIA archive.
But between doing that and just providing a very cursory report, not even justification, I think we can find something in between. And to me,
I don't disagree.
Okay,
but you can see the consequence of the way the U.S. approached it is that very few people believe the United States. So that's the direct consequence of the way they decided to do it.
I'm not sure they care. While I believe the public opinion, I don't think under this current presidency there is much interest in international public opinion. I also think that the problem with what is being done is that whether or not this was the intention, there is a push to increase further the doctrine of self-defense.
Yes, corrosive, basically.
Exactly. And by not insisting on further explanations, by not demanding greater justification, we're basically normalizing it. That, to me, this is why I was, I said Soleimani is a significant development, doctrinally and practically.
Before opening as a moderator, I would like to make two remarks. The first one is Harvard University has a very interesting project where it has documented all the letters that have been sent to the Security Council under Article 51 justifying or reacting to use of force. So I think this speaks to
I'm working with them
and how it is developing at the moment. And on states' reaction and state providing information with regards to targeted killing, it's not a legal article, but the New Yorker has done a very interesting article after the strike against Qassem Solemaini, explaining how basically targeted killings against state officials is not necessarily a new practice, but it was done in secret and states were not used to basically claiming it as the way the US has done now. It's a very interesting read which I can highly recommend. We have two questions at the front. Is there a third question? Okay, so we'll have two questions at the front, a third question at the back, and then if we have time, or if you're patient, maybe the fourth one over there. Sir?
So I'm a retired U.S. Army officer and Guantanamo defense attorney. So I've had a first-hand look at the destruction of international law by the United States over the last 18, 19 years. And so I would argue that this, instead of this legalistic wordplay, as I've heard somebody use the term one time, there should be sorrow or outrage, I would suggest, over this killing of Soleimani, because it's one more nail in the coffin of international law being driven in by the United States. The United States doesn't even acknowledge international law anymore, contrary to any views here. I'm on the case where they invented what they now call the domestic common law of war of the United States. This was in the case of Bellum. When we argued that it's a violation of international law to try him for certain reasons, constitutional law, they said, well, this is a violation of domestic common law of war, which is what they recognize. Alberto Gonzalez said years ago, Geneva was quaint and obsolete. Take them seriously. That's been the U.S. interpretation of international law ever since, whether under Trump, under Obama with his targeted killings and other things, or specifically under Bush and Cheney. So I guess a couple points that were raised, and your point about Hobbesianism. I mean, this has been doctrine. This is the doctrine of the United States, that we are the Leviathan, and that we are the upholder of whatever we believe is to be the law at any given time. So when it comes to jurisdiction, the United States asserts jurisdiction over the entire world. That should not be a secret anymore, or that should not even be disputed. When we go in and kill somebody in Iraq, whether in 2003 or in 2019 or 2020, we're merely asserting our global jurisdiction in our view that we rule the world as we declared in the National Security Strategy of 2002 and repeatedly ever since. So I guess I just want to bring that point up, is why it seems like we generally, the last point of Ms. Cullivar, we're normalizing this. We're continuing, the international community continues to normalize the violations of the United States repeatedly. Actually, I was looking quickly, Article 2, the prohibition of aggression. It would seem to me that this was exactly that case, a government official that we kill in a foreign country, but nobody's talked about that. But why haven't they? Because it's a series. When you look at it, it's just one more in a series. You mentioned cyber war. The United States and Israel created Stuxnet to attack Iran. Iran has been under continuous attack, and General Wesley Clark pointed that out years ago, that we had 7 countries that were going to come under attack in succession. So I guess my point is simply, why are we obscuring the fact that the United States doesn't even recognize international law anymore?
Thank you. Sir?
And thank you. I would like to thank the Academy, Geneva Academy, for organizing this meeting, and also thank the boss, Marco and Agnes, for their informative presentation. I had just 3 points. First of all, that the General Soleimani's killing should not be reduced to the assassination of a regular person. Mr. General Soleimani was the senior military commander of a country, as is a manifestation of sovereignty of a country, who was invited by the sovereign country, I mean Iraq, to combat the terrorism. So but the picture that the US making of Soleimani is something different. But he has been in the front line of combating terrorism, Daesh and other terrorist groups. And another issue, the Marco has mentioned a good point about the shifting of the argument. I know why they shift from this argument to other argument, because the U.S. administration has a specific definition of international law. From their perspective, international law is justification of their act, because they have done it and they try to find some justification for how to. Oh, there is a memo. They put forward the memo to the Trump, and how can we justify this issue? This shifting is so. Just you remind me, and also you remind me of the advisors, legal advisors. When the role of legal advisor, when the U.S. attacked Iraq, intended to attack Iraq, the U.S. foreign minister asked his Britain counterpart, "We want to attack Iraq because there are some chemical, some other alibis." But the foreign minister of the Britain says, from legal point of view, according to the legal advisor, it is violation of international law. But the U.S. foreign minister says, there is no problem, you just change your legal advisor. Here also, the third point is that about Iran's action. It is not comparable, the Iran action and other U.S. U.S. action was, the U.S. has not been able to justify its action. You see the different sources, you look at different sources. But the Iran has acted in exercise of the self-defense, and also we have considered, we respect also the IHL. There was not any collateral damage. But as our colleague, you said last sentence, my colleague from Iraq referred to that in addition to the Iran commander, the other Iraqi also was killed. So it is the U.S. and the international community should take this seriously, because it steps back to the era before the charter. And we should try not the rule of law prevail, not law of the rule.
We have to excuse Agnes Kalama, who unfortunately has to leave us. But if you all agree, I would like to give the floor for the last question and then give the two Marcos a couple of minutes to reply.
The duet of Marco.
Yes. Luca?
Yeah, thank you. Thanks. I hope I can make the question very short.
Thank you.
This is related to proportionality assessment in the IHL now. So I would just be interested for the two Marcos. Specifically, how would you assess the military advantage of killing this general, and how would you do that without looking at the overall goal of the operation, and how is this not also linked to the Bellum issue?
Thank you for the question.
And now you're leaving in protest.
Well, I mean, that's my question, since you rejected my position. I'm dying to listen to the answer.
Well, then
are you
please
taking
answer.
a train or?
Okay, Professor Sassoli, do you want
Question?
Yes, obviously, I mean, proportionality has to be dealt with in both use ad bellum and use in bello, but separately.
Yeah,
So,
I agree.
under use ad bellum, the proportionality must take into account all this, and you know that we have a little disagreement that I think you should not individualize about General Soleimani this, but it's a question of proportionality between the threat, the alleged threat by Iran and the reaction by the United States, while proportionality in use in bello have nothing to do with that, but even the aggressor, which clearly violates Article 51, can nevertheless comply with the proportionality requirement, because the proportionality requirement is between the military advantage, and even the aggressor has a military advantage, and the civilian.
But did it apply to that case? I think this was my question. I was not making a general statement. I was asking whether in that particular case it applied. In that particular case, can we suggest that the military advantage of killing Soleimani met the proportionality requirement under IHL? And that I had doubt. That's why I was not convinced.
Your question is, how does one define the goal of the armed conflict?
Exactly, in that context,
Yeah,
and
but
therefore how
don't
can
say of the armed conflict, of this operation,
of this
because
operation.
Yeah.
I am very sorry. I have another event
So,
to rush to.
goodbye.
It was a pleasure.
Thank you so
very
much.
We know your position on proportionality. Do you want to share yours? If it differs.
To be honest with you, I would have to think more about this question. I'm not trying to evade it. I'm just not entirely sure. So my intuition is to go with Marco just said. So if we accept that in a completely illegal invasion of a country, the Iraq War 2003, the aggressor, the United States, can still lawfully, as under IHL, kill civilians in pursuing legitimate military targets, the assessment of what's a concrete and direct military advantage anticipated, which is part of the proportionality test, has to be on a much lower level of analysis than winning the war in some righteous way. It has to be basically, does this help us and hurt our enemy? And hurting the enemy by killing a high-ranking general, the probably one of the highest-ranking generals in the armed forces, to me, a relatively straightforward thing. And not only is that the case, it also means you can kill a lot of civilians to kill that very valuable target. So if 50 people died when you attack the commander, the commander of the Joint Chiefs of Staff of the United States Armed Forces, that's fine. Probably that's fine. So IHL is not a nice body of law, is what I'm saying, basically. So it's human rights law that is much nicer in that way, if you want to go along these types of arguments. But there's a reason why IHL is designed in that particular way, for reasons Jelena gave, which is that you want to apply it in such a way to avoid questions of who started it, who's fighting the just war, who has the better argument, who started it first. And that's why it's like that. But I understand the underlying theoretical sort of issue in your question is not an easy one. So I hope you're not completely unsatisfied. On your second point, also coming back to your colleague from Iraq, I would just say that Iraq quite rightly and quite consistently wrote to the Security Council to condemn both the US strike against Soleimani and the Iranian strike in response against the US military base in Iraq. And it condemned both as unlawful uses of force and as violations of Iraqi sovereignty, and that is right. On a political level, killing Soleimani and the deputy head of the militias in Iraq and various other people who were killed, Mohandes and the various other people who were killed in the strike, is obviously much worse or consequential than causing concussions to some dozens of US soldiers. I mean, obviously the harm in political moral terms is much bigger in one than in the other. That doesn't mean the Iranian response was not unlawful. On the contrary, it's easily unlawful. So the US people have some arguments about imminence, ongoing, whatever stuff, that it's impossible to answer without unpacking the evidence, and we don't have access to the evidence. But just responding in retaliation, even if the revenge is proportionate, it's still revenge, it's still unlawful. And sir, to your point that international law is dead and that the United States thinks it's dead, you're right.
Unfortunately, they are not alone.
Well,
otherwise we would live in, I would dream of a world where only the United States has problems with international law.
Every state uses international law instrumentally. Every state, not just the United States.
The scale is different.
The scale is different because if you're more powerful, you're more likely to use it. But even they cannot ignore it. They had to speak in that language. President Trump couldn't just go out publicly and say, we killed Soleimani because we wanted to. It doesn't work, that type of argument. They had to use the language of self-defense and international law to make even a reasonably plausible argument. Now, you might say that's a fig leaf. Well, that's what lawyers do also, which is to provide fig leaves.
Why do international law lawyers accept this?
We don't accept it. I mean, it's just spent like hours saying we don't accept it. So that's not true.
Yeah. Well, I think on that last note, I think one of the things this panel discussion shows is that international law is not dead, because it's been a very lively discussion. And that, what I take away from the discussion is the necessity to both separate the legal frameworks from one another, IHL, human rights law, and then you said Bellum, and then to the extent possible separate the political considerations from the legal ones, because they do not lead to the same results necessarily. But I hope that you have found this interesting, and we'd like to thank the two Marcos for sharing their views, and I wish you a wonderful afternoon.